BKB are delighted to bring you their new podcast, More Than Just Numbers. Join Ali and Luke, along with guest speakers, whose aim is to help you navigate through your business journey. Business is more than just numbers, and at BKB, the team provide financial direction and leadership, so each episode will cover a different topic that will help you and your business grow. We hope you find this episode of value.
So welcome to our latest podcast. Today we're delighted to have Lacey's Solicitors as guests on our fifth podcast in the series. Lacey's is a leading, forward-thinking local firm with specialist experts serving both individual and business clients across a broad spectrum of practice clients. Joining us from Lacey's today is Natasha Jones and Sam Freeman. Natasha is a member of the corporate and commercial team, as an experienced corporate lawyer, having trained and practiced in London for many years before relocating to sunny Bournemouth in 2015. Natasha has advised a range of businesses and individuals across different sectors, and her practice focuses on acquisitions and disposals of both shares and assets, general banking work, and in particular real estate and asset-based finance, company restructures, shareholder agreements and partnerships. Sam is head of the corporate and commercial team and is a vastly experienced corporate lawyer, having advised a wide variety of businesses with a range of sectors, including ourselves. Sam's particular specialisms include share and asset acquisitions and disposals, company restructures, shareholder agreements and partnerships. Sam enjoys helping people succeed in business, regardless of whether the client is a small local setup or a large national organisation. So today, we're going to talk around shareholders agreements, corporate governance, and something that seems quite topical at the moment, in how to incentivise employees. So we're going to start with shareholders agreements then. So Sam, I'm going to ask you the first question, which is quite a straightforward one. What is a shareholders agreement?
I like to start with a nice straightforward question. So shareholders agreement is exactly what it says on the tin. It's an agreement between the shareholders of a company, which is separate to the Articles of Association and allows them to govern the relationship between themselves. The benefit of it being separate from the Articles of Association is it's not recorded anywhere. So it doesn't have to be filed at Companies House and nobody can download it and just have a little snoop through what their kind of private arrangements are. So it just encourages people to be quite detailed about how they want to interact with each other. Often with the key things being decision-making processes and transfer of shares. So if anybody wants to get out or if they're collectively looking to sell, what the process is.
That's great. How do you start a shareholders agreement? What's the starting point? And don't say see a solicitor.
Actually, the best starting spot is agreeing between the shareholders that they want to have one, as opposed to just one of them deciding it's a good idea. After all, you can't force people just to sign up. So that sounds stupid, but it is stage one. Once you've got that, there's lots of different ways you can go around it. But the earlier you engage with a professional to guide you in the right way, the quicker and easier the process is. Because there are some potentially difficult conversations between individuals because you're basically planning for the worst. And the earlier you have those conversations, know you're all on the same page, you know it's worth going ahead, you will get an agreement you can sign off. And you don't waste time having conversations that either aren't quite on the right track or sort of covering things that you may or may not include.
And I guess ultimately what you're saying is the point is to engage in dialogue with each other and come to a lawyer with a plan, a broad brush plan to say, you know, we've had the difficult conversations, because it's easier to have difficult conversations at the beginning when there's no effective money involved than it is at the end of a relationship, I guess, isn't it?
Yeah, absolutely. So if you do it at the beginning, there's less money involved, and actually, to be blunt, everybody is getting on. And that's obviously the best time to reach an agreement. It's possible, but really hard to put together a shareholders agreement that everyone's going to sign if they've already started to fall out. So, you know, it's possible, but it's the horse that's already bolted to some extent. So the only question, the fair question, is it obviously comes with a cost. And so what's the right time from a kind of a benefit and cost balance to do that? So if you look purely at the benefits and the you know the risks it covers off, it's the earlier the better. But someone starting a business, there's lots of costs, so it's just got to be at the right time.
And what sort of basic things would you put in the shareholders agreement?
So yeah, the two biggest areas which would be covered would be who can make what decision. So can a certain number of people or percentage of shareholders force decisions? Does anybody have rights of veto where there's certain areas they can actually just block decisions? And then the transfer of their shares. So that might be, if a shareholder has just decided they want out, then can they just go and sell to a third party, because that can be really damaging to the business or the other shareholders? Do they have to offer it to existing shareholders first, etc.? Try and keep it in house. And if somebody is someone leaves the business, so they're no longer working in it, do they have to sell their shares, or they can just walk off and continue to own them? If somebody dies, that's quite a obviously we all hope we're not going to, but unfortunately it does happen. So otherwise those shares would just fall to an estate, and that can be no problem at all, but it can also be really difficult for those that are still trying to run the business.
I remember when Luke and I were doing our shareholders agreement all those years ago, and there's one thing that you said to me, or said to us both actually, was the more complicated you make the agreement, the more costly it becomes. Is there kind of a balance between, because a lot of listeners listening to this will think, well, I don't want an overly complicated agreement that's going to cost me tens of thousands of pounds, but at the same token, I don't want to effectively download one off the internet for 200 quid and it not cover everything I need to do. Is there a balance that people can get to?
There definitely is. Unfortunately, we're lawyers, and we've gone through all of those areas where you just end up in disputes. So a simple shareholders agreement ends up being several pages, and if you short circuit that, you've just left grey areas. But if you like, that's kind of the words, that's the detail, that's the mechanism for us just to cover off what somebody actually wants, so that we know that in practice, if you're ever looking to go back and use it, it will work. The principles are quite easy at headline, and then they obviously shuffle down into sort of a little bit more of the finer detail. The way we tend to approach it, there's no right or wrong way, is that we've got a checklist of questions which we give to clients, and it just makes sure they go away, they take the checklist, they talk through that themselves, which is back to that communication, making sure they're all on the same page. But they can do that in their own good time. And it means that we know that they've thought about all the key areas. They might not want to include them, but they've at least had those conversations. Generically speaking, 75% of the questions get answered, 25% are, we're not really quite sure what this means. And that's great. We come back, we have a chat through with them, you talk them through the consequences, guide them slightly to what might work best in their setup. And at that point, it's a really easy way for us to get really good instructions that's just covered off everything they want. And it means that kind of first draft document, whilst it looks longer than it needs to be, it actually covers all of the areas, but also makes sure it covers all the key points the client wanted. So we make it kind of easy, if you like, by stripping out the length.
And one question I get asked a lot, and I'm sure Luke's the same here, is we get asked by shareholders when they come in for their first meeting, and we obviously talk about getting a shareholders agreement, and the question they always ask, do I actually need one? And I guess legally no, but we always say yes, or certainly encourage. What would you say to that?
No, I completely agree. So there's absolutely no need for them to have a shareholders agreement, and there are lots of businesses that don't. And I always think the shareholders agreement, your best way to look at that is it's like that insurance policy. You hope you never need it, but if you do, you'll be really pleased it's in the drawer. And often knowing what happens in a dispute or something, that actually even stops the dispute happening in the first place. So yeah, absolutely. It's fair to say there's no need for one. It helps give people peace of mind, helps avoid disputes, and also helps settle disputes if they do arise, because unfortunately they do.
And is there anything, Natasha, what do you want to add?
I think, and I agree with obviously everything Sam's just said. I think what we do see is that, particularly if these discussions happen at an earlier stage of a business, because of the nature of the discussions around a shareholders agreement, it can lead shareholders down perhaps a slightly different route of discussion than they might otherwise be having when they're excited about their idea and they're putting it together and they think that they can work very well together and complement each other. And sometimes the process of discussing it and working out what they're expecting of each other through the business, and what would happen if they were to fall out, helps them realise whether they can in fact work together, and whether they could work together in times of perhaps stress or difficulty.
Luke?
I think, and what you're saying there, Natasha, with a lot of our clients, they're family-run businesses, and often families say, "Oh, we don't need a shareholders agreement, we're families," but actually they can actually be the ones that need the shareholders agreement more than anybody else, because they tend to fall out quite badly when it comes to business and money, and we see that quite regularly, unfortunately.
We do. And the shareholders agreement and wills kind of go hand in hand as well, don't they? And I know you two don't do the wills aspects at Lacey's, but you can see shareholders agreements and wills working in, they need to kind of be in sync with each other. Which one is top dog out of shareholders agreement and wills? Because that's another kind of myth between people.
In an ideal world, they work together. But the one thing you can't control if you're a shareholder is what your other shareholders go off and do in their wills. So, and also what they've told you they've done today, they might, next week, tomorrow, 2 years' time, they can go and change what they've done in their will. So as a shareholder, you can't rely on what someone else has put in their will for your peace of mind that the shares will end up where you hope they will or expect them to. So, but ultimately the will deal with the deceased individual's assets. So if you like, from that perspective, it's kind of it's the top dog. But what the shareholders agreement can do is kind of effectively get in there first. For example, if a shareholder was going to leave all their shares to their husband or wife, but the rest of the shareholders have no interest in being in business with them, they bring nothing to the business at all, the shareholders agreement can kind of put in place an option to buy out those shares. So that sort of kicks in the day immediately before death, hence getting in there before the will. And what it does mean is it just gives the shareholders an option. It's normally an option rather than an obligation. So they can buy those shares back off the estate if they want to. So the estate ends up with however the valuation is put in the shareholders agreement, but normally a fair value for the shares. So they get a lump of cash instead of actually getting the shares, then leaving the business and the other shareholders sort of carry on drive forward without sort of an unknown or unexpected party involved.
And I suppose a driver to that as well, to get to fix that now is quite often when we have shareholders and a board of directors in front of us, and we say, okay, so if one of you dies, how do you get on with the spouse of that person? Do you want them in your business? And quite often the answer is no. At no cost do I want that spouse in my business. And so, well, how are you going to? Because do you know what's in their will? How are you going to do that? How are you going to incorporate that into your agreement? But it's quite often gets people's attention or focuses people's attention when you think, well, how well do you get on with those spouses?
And there's a big difference between being really happy, at a dinner party, sat next to them, chatting away over a glass of wine, as opposed to sitting around a boardroom table trying to make some sort of commercial-based decisions. It's a really different relationship.
I think just to add to that is quite often with smaller owner-managed businesses, the shares are given to people who are contributing to the business, who have specific skills that they can bring. And if that the husband or wife of the deceased shareholder might be able to do that. If not, you're probably going to need those shares back to be able to give to somebody else to perhaps bring into the business to carry on the success. So not only do you not want to be in business with the person that might then hold the shares, you might need the value of those shares to be able to pass on to somebody else. So I think we see that.
Okay. And do you find that the shareholders agreement gives some business stability? I take it from you write the agreement and then hopefully you never see them again until something is needed to be enacted. But do you get many people come back to you? Do you recommend that people should review their agreement periodically, every 5 years or something like that?
Yes is the easy answer. Although I would also have a very good stab in the dark that most don't, and they only review it when they're almost forced to. There's been a change of circumstance, but yeah, it's always a good idea to review it. I think probably the biggest practical testament to it is that those people that have been in business before and it's not necessarily their first venture, and have seen the good and the bad of having and not having a shareholders agreement, they almost always want one. And if you're a serious investor looking to put money in, you would want one. So, you know, if those people who have done it, been there, seen it, they think it's a good idea, it probably adds testament to the fact it is.
Excellent. Okay. Is there anything that anyone else wants to add about shareholders agreement, or should we move nicely on to corporate governance?
I mean, that's a great sidestep, isn't it?
Great sidestep, yeah. So, Natasha, what is corporate governance?
Corporate governance is essentially really complying with corporate law and all of the rules and regulations around companies, but essentially what we are dealing with is the Companies Act, and companies are subject to both the Companies Act and also their Articles of Association, as Sam mentioned earlier, which is the effectively the constitution that runs each company. Corporate governance is just something that it's not particularly exciting, unfortunately, but it is like paying tax, which is obviously your side, something that has to be done.
I did wonder how we were going to make corporate governance exciting in a podcast, to be honest, but we're going to give it a go.
So that it has to be done, and it's something that can come back and cause some issues. For lots of people, they just sort of carry on and sort of hope for the best, I suppose, or they don't realise what they should be doing. And I think that's the biggest the biggest issues we see are where companies have tried to so they've set up their own company. They have tried to undertake certain actions involving the shares, principally the shares or assets of that company, and then they haven't taken advice on what they need to do to formalise that and to regulate it and to authorise it in many cases. So that's where the certain documents, forms must be filed with Companies House, and that's the register that is public, that is what's checked, and that's how that's how the world knows that those companies have complied with what they need to do to be able to take any action. So there are that's what has to be done. There's then best practice, which is for directors. They are under duties, and that's another whole issue that we won't go into here. But in complying with their duties, they must have considered every decision that they're making for the company, and in the first instance, they owe a duty to the company and the shareholders. Those duties can change in certain circumstances, but it's really important that any decision made by a director has been fully considered, and the best way to show that it's been fully considered is to evidence it. And if there are any problems in the future, or there are disgruntled shareholders or creditors, then if you can point to a set of board minutes where you've evidenced that the discussions that have happened between the directors and the resulting resolution or decision that's been made, then it's a lot easier to deal with problems in the future.
A lot of people think that board meetings have to be done very secretively in a meeting room, and you have to come up with an agenda and give notice of board meetings, and it has to be very formal. But when you're talking about a husband and wife business, or just, from Luke and I's perspective, does it have to be that formal, or can it be a little bit more informal, as long as something's being taken? And
yeah, I think it's I think any decision that's being made, certainly something that's going to affect the future of the business and the decisions that are made, and have an impact on the business going forward, you would want to have documented in writing. So that can be an email between you. Ideally, you would both acknowledge that you've seen that. So if there's an email, perhaps just some notes set out, perhaps both have signed it, or it's sent by email and it's acknowledged back by email. So on an ongoing sort of basis, that's what we'd recommend. There are certain decisions that are taken which are governed by the Companies Act or your articles, and which do require a greater degree of formality. So if decisions are in fact to be made by the shareholders, the owners of the company, rather than the directors of the company, then there ought to be a written resolution passed between the shareholders, and that does have to be circulated following a board meeting, and that board meeting needs to be quorate and have held without and properly convened. and be able to continue. The discussions need to be able to continue without a risk of conflict, or the conflict having been waived. So for example, if you wanted to change your articles, or you wanted to change the rights attaching to your shares, then that has to be agreed by the shareholders, it has to be agreed by a certain percentage of shareholders, and that has to have been circulated for consideration at a board meeting. So there are areas where there are certain formalities, and then that has to be recorded at Companies House. And this is where we see time and again with sort of new clients coming to us, they don't have that the correct forms filed at Companies House, and therefore it's misleading as to what's there, and they might not have in fact created, for example, a new class of share that they'd anticipated that they had. And if you've got shareholders with different classes of share, and they're perhaps receiving dividends differently because of that, and then they haven't properly created those separate classes of share, then there can be an issue about whether they were entitled to pay the dividends differently, or whether actually they've been doing something, potentially wrong. And there can be, coming back to tax, there can be tax repercussions. There are fines and penalties that can be charged for not filing or undertaking those correctly. But the main issue is the other consequences. So, tax and sort of difficulties that come up.
And on the board minutes, do you have to take, like, literally be verbatim, word for word documented, or can things be summarised to say, Luke and Ali discussed this, this is what they discussed, and this was the outcome of their meeting, or can it be, or outcome of the decision, or can it be less formal than that, or how
absolutely less formal? So the idea is that you've got, like, the minutes for any sort of meeting, or the notes that you might have, but it's the essence of what was discussed. If you if you're in total agreement, then you can just bullet point the points that you've talked about. You both agreed, you can make a note of that. If there was anything that perhaps somebody raised as a point to consider, or perhaps revisit depending on certain circumstances, then also you'd want to make a note of that. And if there are any actions arising out of it, then just make sure those are followed up on. But it certainly doesn't need to follow set for formalities, as long as you've made it clear that you were both at, who attended the meeting. You keep a note of the time and date, and as I say, anything that was that you particularly wanted to flag to, and if you came back to it in the future, if in two years time you came back, is there enough information that you're going to remember what you talked about?
Okay. And some of the more, I've experienced some of the more formal, where you've got a board of 6 or 7 directors, or even more. And one thing that is commonly talked about there is resolutions. And so what is a resolution?
So resolution is a decision. It's proposed, and it's then considered, and hopefully everyone has an opportunity to consider it, to understand what they're being asked to make a decision about. And then they all get a chance to vote. And depending on the type of, so if it's a Companies Act resolution, if I can use that phrase, then there might be a certain percentage of shareholder votes that need to be passed for that resolution to be passed through. So that might be more than 50% of shareholders need to vote on it. It might be 75%. And once that,
do you need to file the resolutions at Companies House at all, or
you do need to file some? So virtually all special resolutions, which are the ones that require 75%, they need to be filed at Companies House. Certain decisions that require more than 50% do need to be filed. So that's where it can be a bit confusing if you're trying to work it out yourself, and if you're not going to speak to a corporate solicitor who can guide you through what does or doesn't need to be filed.
I was just going to say that when you're putting a resolution together, do the board need to consult someone like yourself to design the resolution and formalise it and get it filed at Companies House, or is it something that people can do themselves?
We would generally advise that they do speak to a solicitor, because there is a format that's sort of expected in terms of how a resolution is set out, what information needs to be included on it, and often the underlying reason for that resolution is something that might need to be considered in more detail. And And the problem is, if that resolution is not correctly passed because it wasn't held at a properly convened core at board meeting, or the resolution wasn't passed in accordance with the Companies Act, and potentially the articles, which might specify something different than is set out in the Companies Act, then that resolution might not in fact have been validly passed, and all of the the shareholders and the directors then proceed believing it has been, and actually it's not. And we are asked on more frequently than you would imagine to try and address or tidy up or deal with issues arising from those formalities not having been properly followed. So we do see the other side of it. I mean, probably not daily, but I would say weekly. We are trying to help companies refile forms, ratify. Yeah, absolutely.
We're trying to deal with one at the moment, aren't we?
Yeah.
That's been ongoing for nearly 12 months, where I think it was 2012, wasn't it? It goes right back to 2012, and the forms, the right forms were not filed to the right people, and we're having to unravel a 2012 buyback of shares, which has gone completely wrong, and we've now got a shareholder who thought that they didn't have any shares, who now are realise that they actually do have shares, and the size of the dividend that person is entitled to is quite horrific, to be honest, for the company to pay out. Great for her, but not what the existing directors expected, and it was a bit of a bolt out of the blue, wasn't it, that one? So
yeah, absolutely, it's a good example.
Yeah, okay. So I'm going to move on to growth shares, because this is something that you, Sam, put in my head a couple of years ago, just before the pandemic hit, and it hasn't really been that topical, I don't think, during the pandemic, but certainly with conversations that I'm having with a lot of my clients at the moment, where they realise their key staff during the pandemic, those that have helped them stay afloat in during all of this, and they want to do something to keep them locked in for a period of time. And something, these growth shares are, I've talked to a few people about them and got very favourable answers. So do you want to give a bit of a background as to what growth shares are all about?
Yeah, they can be a really useful tool in the right circumstance. So that the one you've identified is one, so trying to incentivize staff. The other real common one is when people are trying to do some sort of planning and move some of their value, some of the value of their potential estate to other family members. They're probably the two most common areas that I see them used. And of course, the problem of just giving someone something or moving an asset is that you can trigger tax. So the good thing about a growth share is that if they're done right and you've got all the right advice and you've done them all properly, is you can start to achieve all these things in a fairly tax neutral position at that stage. So in their simplest form, a growth share is a share that on day one, when the person receives them, they don't have any capital value. So they, if the business was sold the very next day, they would get nothing for that. But what it does is, as the business grows, they have a share of the growth. So you would value the business on day one. So let's keep this really easy for my maths, not being an accountant. The business is worth £1 million day one. The growth shares will be worth nothing if all the time the business is worth £1 million or less. As soon as the business is worth more, that individual that has those shares has their percentage of that increase, so the growth. And so it's a good way of moving that kind of future growth, that future value, or some of it, to other individuals. And it's you can attach different conditions to it. Let's use that word. So if they're particular, individuals who have just done really well through the pandemic, you're looking to incentivize them. You can always have the option that those shares are they're cancelled in a particular way, or they have less value if they stop working for you. So it's not like you're stuck with that forever. But it's just all about how can we not give someone a big tax bill, but achieve the goal of either incentivizing or moving some value.
They don't have to buy in either, do they? That's the thing.
No.
Like you said, you're setting the clock at zero. So there's no buy-in amount. There's no tax to pay on giving them the shares. What sort of rights would attach to the growth shares? Because normally shares have dividend, voting and equity rights. Would growth shares carry all those three rights?
That's up to the person granting, or the other people involved, those that are granting them. So, you can restrict them from having voting rights or rights to dividend, or you can leave them with that. Of course, it's something to do having taken legal and tax advice, because there can be knock-on consequences if you start playing with voting rights, etc., down the road. But otherwise, you can set them however you want. It's quite important to think about it carefully before you issue them, because whilst you could potentially change them at a later date, you probably are walking into a dispute. So have a good think about what rights you want that individual to have, and then make sure that's clearly set out when you actually issue these growth shares.
Because a lot of clients I've spoken to said, well, I'm quite interested to give my staff some incentive that if I sold the business, that they would get a share of that based on the growth from whilst they're with me. But I don't want to give them any voting rights. I don't want them to have a right to dividend. But that and you're saying that's absolutely fine. That's perfectly acceptable. You just need to factor that in at the beginning when you're creating the shares.
Yeah, but it back to the importance of doing it properly. So, and this is creating any class of share. It's just amazing how many times we see people who believe they've got various classes of share, or believe that different classes have different rights, but the paperwork just doesn't reflect that. So in truth, that probably isn't the case. So doing it properly, and again, even if you can see that that whoever's done it for you has put that there's no voting rights, for example, and that's all it says, that alone would mean that individual would still be entitled to notice of a meeting. So still kind of have an idea of what's going on. So that's just back to make sure you're getting the right advice so that it's all neat and tidy and exactly as you want it. Excellent.
Okay. Natasha, have you had any experience with growth shares at all that you've want to share? Or?
No, I mean, like you've said, really, I think in the last couple of years, companies have been a little bit more in sort of survival mode, or just making sure that they're sort of maintaining the status quo, and so not so much, but as you say, starting to discuss what they can do going forward. I think, and one conversation I've been having with a client, and we've growth shares in exactly that way. What wasn't out, it was considered as part of it. Options were considered. They were trying to find the right route to move forward for the company, and they'd already promised to the employee that they were going to get this value, and the difficulty that we've had is we've been trying to work out the best way forward, and they keep saying but we've already promised this, or we've already promised that, and they're waiting. And so what I sort of add to it from the human element, I think, is make sure that you get your advice and know exactly how you can and want to proceed, and the costs that are associated before you start making the promises to the employee about what they're going to get.
So all of everything that Tash said is just correct, but I'd probably trying to wrap up growth shares, because I'm sure the listeners are really interested in that, would be that I think they're a really, really powerful option, but they're not the only option, especially when we're talking about incentivizing staff. So again, it all falls back to just getting the right kind of tax and legal advice right at the outset, because there are just ordinary shares as opposed to growth shares, which come with very different pros and cons, and there's also just options. So they don't actually have shares, but they have that potential benefit if there's an exit or after a certain amount of years. So people who don't sort of necessarily know the full options available to them with the pros and cons, there's lots of different ways to incentivize staff along similar lines, and so it's just that get that really good early advice so those what route you want to go down.
I think that's a really good summary of this podcast as well, actually, is that is to get advice at the beginning, because you can spend £1,000, £2,000, £3,000 worth of advice at the beginning, but it's almost like an insurance policy, and you guys are like an insurance policy in that if you get the right advice at the beginning, it can save you an exponential amount of money in disputes, and we've all seen situations where things have gone wrong, where people haven't got advice at the beginning, and at the end, when it because they've not got that advice, it can create a tens or even hundreds of thousands of pounds worth of costs at the end of a relationship, effectively.
It's so true. We see it all the time where the kind of perception is I'll do as much as I can and then I'll go and talk to my lawyer or my accountant or whichever professional it is. And very occasionally that might be prudent. But almost always, the earlier you speak to your accountant, the earlier you speak to your lawyer, whichever professional, you go off on the right path. You don't then have those difficult conversations where you promise someone something and now you're trying to backtrack. Or, if you're doing some sort of transaction, your heads of terms are actually covering all the key areas. It's almost always actually a time saving and therefore a cost saving by engaging early. But it's just, people don't necessarily see that. They think, oh, if they're engaged for longer, it'll cost me more. And it's normally the reverse.
Excellent. Okay. Well, that's great. And I'm really pleased that Sam and Natasha have joined us for the podcast, and I hope you guys have taken something away from it. If you've enjoyed today's podcast, then as always, please give us a 5-star review, and we'll send a prize to the best review. Yet to be decided what that prize is, but that depends on how good the review is. So thank you very much for listening, and thank you very much, Sam and Natasha.
Thank you.
Thanks for having us.